This program is brought to you by Emory University.
So this presentation is also one of the ones that Suzanne mentioned was planning for death and incapacity, and that's kind of what this presentation is, but I like the title that Emory chose much better, Winning the Endgame. It's a bit more cheerful. I always, it takes folks a lot of times to get into my office to come see me sometimes, and they say, gosh, I've just been putting this off, and I can't understand why people don't want to come and talk about death and incapacity. So, I like the title of Winning the End Game with regard to estate planning. It certainly sounds a lot more inviting. So why worry about estate planning in the first place? A lot of common things that I'll hear from clients is, I'm going to be gone, I don't care, it doesn't matter to me, or I don't have that much stuff, I don't need to worry about my estate planning. But really, planning ahead, getting your estate plan in place is really a gift that you can give to your loved ones. It helps them. If any of you have ever stepped into the shoes of someone else, whether that person has passed away or is no longer able to handle their own affairs, you know what a mess that can be. So getting your plan in place is really a gift that you can provide to your loved ones. So that was my touchy-feely answer. Here's another one that sometimes resonates more with people. It allows you to stay in control. Not that you're trying to reach from beyond the grave and control how everything goes, but it does allow you to make decisions with regard to how your things are going to be handled. If you are still living and just not able to do things on your own, or even if you are deceased, then it does give you the opportunity to remain in control and have some sort of say-so in how things are going to be handled. So with estate planning, there are a few basic elements. People tend to think, oh, I got my will done, my estate planning is over and done with. So it's important to realize that there is actually a lot more to estate planning than just a last will and testament. We've got powers of attorney, titling of assets, beneficiary designations. There's the will that we would have mentioned, or maybe putting a trust in place. And then also part of the underlying factor here that a lot of people are concerned with is, what does this all mean tax-wise? So all of that plays into, okay, what is estate planning? Well, it's a combination of all these things, not just a last will and testament. So we'll start first with planning for incapacity. Incapacity is a time when you are not able to make your own decisions any longer. Maybe it's permanent. Maybe you've gotten a diagnosis and things are only going to get worse from here on out, or maybe it's just temporary. As you're rehabbing or recovering from an accident or a stroke, and there's going to be some recovery. So incapacity can be temporary or it can be permanent. Without planning, in other words, something happens to you and you never got around to getting all this stuff done, a court can step in, take over, and make those decisions for you. They can put somebody in control, might or might not be who you would have chosen to step in and take control. But the court will put that person in play, and then also the court continues to supervise. So it's an ongoing operation. In Georgia, that's known as guardianship and conservatorship. Guardianship would be the person who's put in place to make healthcare decision-making, living arrangements. Conservatorship would be the person who's put in place to make financial arrangements. It can be the same person, very often is, but it doesn't have to be. But by getting your planning done, planning ahead for incapacity, you can keep the court out of things, keep the court out of your business, keep that stress at bay of having to go to court and actually get a formal hearing for setting those things up. Planning also allows you to determine who it is that's going to make those decisions. Who is it that you want to step in and handle your finances? Who is it that you want to step in and handle your healthcare decision making? Powers of attorney are the solution here, and Dr. Hug is going to talk about the Advanced Directive for Healthcare, and I'm very interested to hear a doctor's perspective on that. So I'm going to leave that discussion to him, but the other type of power of attorney would be a financial power of attorney. A power of attorney is a written instrument by which one person, that's the principal under the document, puts someone in place to make decisions for them when they are not able to. You can confer upon that person very broad authority, or you can confer them only specific bits of authority. And the best example I can think of for a specific power of attorney, for instance, is like a real estate closing. I can't make it to this real estate closing, so I'm going to designate my husband to sign off on all these documents for me, but that's the end of his authority. As opposed to a very broad power of attorney, which lists all sorts of transactions and says basically, I want my agent to be able to do anything that I could do on my own behalf. The person that you name under that document becomes your attorney in fact, and this is a distinction that I like to point out to folks. In fact, just this week, I had a client who was looking to do some planning for her mom, was adding herself to a bank account and changing some funds over, and all under the power of attorney, and the bank presented her with a document that needed to be executed by the attorney in fact. And she emailed it to me and said, you need to fill this out for the bank. And I said, no, attorney in fact, that's actually you. It's just a fancy name for an agent, has nothing to do with being an attorney at law. So I like to point that out because it comes up quite frequently. So in Georgia, we have the Georgia Advanced Directive for Healthcare, which again, Dr. Hug is going to talk about, and then also a durable financial power of attorney. The power of attorney can be specific or it can be general. I've already gone through that with the real estate example versus the broad power of attorney. I certainly recommend a broad power of attorney, making sure that you are giving someone the authority to truly step in and take over for you. You want them to be able to liquidate assets if they're needed for your support. You want them to be able to close accounts if it turns out that you've just got all these accounts all over the place and they want to consolidate things into one. You want them to have all these authorities that could be granted under a broad general power of attorney. A power of attorney, when you sign it, it can be immediately effective or a springing power of attorney. A springing power of attorney is one that springs into effect upon some contingency, and the power of attorney would say what that contingency was. A lot of times it might be a note from your treating physician saying that you're no longer able to handle your finances. It could be a family committee. A lot of times if we've got 3 kids, maybe there are 2 kids, and the power of attorney would state, upon the consensus of my spouse and 2 of my children that I can't handle my affairs, then this power of attorney springs into effect. I am not a big fan of springing powers of attorney. It leaves too much at risk, too much open. What if we can't get those contingencies? What if it's because one kid, it's not that he doesn't think that dad can handle the finances anymore, it's just that he doesn't really like the fact that if he consents, the other brother then takes over. So, dad's perfectly fine. I'm not, signing anything saying he can't manage his finances. So in that instance, springing power of attorney, I think it just leaves a lot of exposure for my client not being able to be adequately taken care of. A lot of folks say, well, I don't want these people to have immediate control over my finances right now. I don't want it to be immediately effective. And that's when I'd say, well, then you need to rethink who it is you're naming as your agent. Because if you don't trust this person right now, when you are perfectly capable of getting online and monitoring all your bank account balances, then are you really going to trust them when you're completely incapacitated and they have ultimate control over all your assets and you are not able to monitor their activities? So I'm the fan of the immediately effective power of attorney as opposed to springing. If you have a power of attorney in place, take a look at it and see if it's immediately effective or if it's springing, and make sure that you're okay with the terms of that. Another thing that people will ask a lot of times is, what's this durable thing? What's a durable power of attorney? That simply means that the power of attorney is designed to survive your incapacity. Even if you become incapacitated, the power of attorney stays in effect and remains in existence and remains valid, even if you are incapacitated. So again, kind of the point of the power of attorney. Also, on the power of attorney, if you're taking yours out and looking at it, you don't see it very often, but I have come across some before that say this document is valid for 7 years, which is great, except if you become incapacitated in year 6 and it expired in year 7 and now we have no power of attorney. So that's kind of another thing to look out for, to make sure there's not some ticking time bomb in your power of attorney that's suddenly going to make it invalid. Selecting an agent. When you put a power of attorney in place, you definitely want to name more than one agent, but my recommendation is that you never name those 2 agents together. Example, we've got 3 kids and I want to name my kids as the agent. Well, I need to pick kid number 1, number 2, number 3, not playing favorites, not trying to hurt feelings or anything. But if I name all 3 of my kids jointly to serve as my agent, the bank can say, okay, well, I see there that you wrote Bob and or Susan and or Ann. We're choosing the and. So we want to know that everyone's in agreement. We want to see everyone's face. We want everyone's signature on the dotted line. And that might or might not happen. So a lot of times my clients will say, oh gosh, I don't want to hurt feelings. And my answer to that is, your smart kid's going to be happy they're not the one that's right there on line number 1. But at the same time, I do understand family dynamics certainly, and it's easy to say that and simplify it, but it can be grounds for some hurt feelings. So I always urge a discussion that goes along with it, saying it's not that I don't trust you, or maybe it is that I don't trust you. Might not want to put that in a conversation, but just make it open, say, hey, you know what, so-and-so's in charge. They're local and they're a financial planner, and I really think that that's the best option. So be upfront about it, but I certainly don't recommend naming joint agents. There's just too much potential for disagreement or just confusion if people tend to say, oh, well, I need to have everyone lined up here in front of me. Even if they are in agreement, it can still just be a pain in the neck to make that happen. So what you would have is your agents named in a hierarchy. We've got 1, 2, and 3. The document itself should state when does agent 2 take over. Usually it'll say something upon the death of the first agent, but what if that first agent becomes incapacitated, and how do we determine that? So you just want to make sure that all of that is covered within the document and that you've got a good document in place. The qualities of an agent, in particular here, talking about the limited scope of my portion here, which is the financial side of things. You want someone who's trustworthy, someone who's financially astute, maybe not someone who knows how to follow the NASDAQ indexes or anything like that, but you want to make sure that they at least know where to go to get the help. Someone who knows that, hey, every year I probably need to look into a tax return, or did mom and dad have a financial advisor I can talk to? So someone who just knows where to go for the information, even if they're not entirely skilled enough to carry it out on their own. Someone who's organized is another very good quality in an agent, because this can be a lot to keep track of. Communicate with your agent and your backup agent. You want to make sure that someone knows not only that they are named as the agent, that they agree to serve as that agent, and then also where might they find this magical document that names them as the agent. You need to have all those things covered. Where to keep the documents? A lot of folks will say, do we keep it in the safe deposit box? Do we keep it in the freezer? Any of those things can be good. The safe deposit box, you want to make sure that at least someone else is listed as a co-owner on the account, in particular with regard to a last will and testament. Because if I have my safe deposit box and my daughter is on there as my agent under my power of attorney, when I pass away, as you'll hear in a minute, that power of attorney is not any good anymore. So she can't get into my safe deposit box to get my original will, which we need to probate, because I'm deceased, therefore my power of attorney is no longer valid. So you want them to actually be on there as a co-owner of the safe deposit box, if the last will and testament is going to be in there. With regard to these powers of attorney, my favorite recommendation on it, I do like the freezer as well, but some sort of fireproof box at home that that either isn't locked or doesn't have a combination code to it, or if everyone knows what that is, because it just never fails that you need the document on the weekend, the bank's closed, it's a holiday weekend, and that type of thing. So I like to have it at home in something fireproof. So who needs a power of attorney? My basic answer is everyone. Anyone over the age of 18 can sign a power of attorney. A lot of times what pushes folks into getting these documents in place is home ownership, because especially anyone who owns a home, you want to make sure that someone has the authority to deal with that home if you become incapacitated. Couples who are not legally married. If I've got, there's a hierarchy under Georgia law for people who are authorized to make decisions, and that hierarchy isn't going to show domestic partner or, partner of 20 years. Doesn't matter. They're not going to appear in that hierarchy, but very well, that's probably the person that I want making my decisions. So in particular, couples who are not legally married, spouse is going to have the first priority. And so you want to make sure that if you're not legally married, that you've got a document in place that says, hey, look to this person for decisions. People without joint accounts, it's also particularly important to have powers of attorney. If you've got an account that has mom and the 2 kids on it, well, even if mom didn't have a power of attorney, the 2 kids can still get access to that account if they're joint owners on it. But there's always going to be one type of account in general that doesn't have a co-owner, and that's going to be retirement accounts. And those are the very accounts that you need to access a lot of times when it comes time for long-term care. All right, it's time to dip into that 401k, it's time to dip into that IRA. And so you need to make sure you've got a power of attorney in place that authorizes someone to do that. When do powers of attorney terminate? Well, I kind of jumped ahead a little bit and told you they terminate upon death. You might see some continuing power in a power of attorney. Generally, it's to make funeral arrangements. So you might see that continuing power. But other than that, those documents are going to terminate. Very important for you to realize if you're listed on someone's account as a power of attorney and that person passes away, if you keep writing checks on that account, you've committed fraud. So it might not have been knowing, but it is now because I told you. But you just want to make sure that you're aware. If you're on an account as an authorized signer, are you a co-owner or are you a power of attorney? Because that power of attorney terminates upon the death of the principal.
You mentioned durable power of attorney before.
Right. Durable, it just survives incapacity, but not death.
Okay, thank you.
A power of attorney may also terminate if a guardian or conservator is appointed. And then you're thinking, well, wait a second, I thought you said if I did my power of attorney, then I wasn't going to need a guardian or conservator. Ideally, yes, that's the case. But suppose I name someone as my power of attorney, and that person then runs off to Tahiti with all of my money. Well, yeah, I have a power of attorney, but it's not a very good one. I didn't do a good job naming my agent. And so in that case, it might still need to have a conservator appointed, even though I did do my planning, and then the judge would say, okay, well, that power of attorney is no longer valid, and the conservator takes over at this point. Also, power of attorney can be revoked at any time by a principal with capacity. It should say in the document itself how you go about revoking it, probably in writing, delivered to the agent. One thing to be careful of, if the power of attorney has been recorded in any county court, maybe in connection with a real estate closing, or a lot of people just by habit, attorneys even will recommend, go file your power of attorney to get it on record. If it has been recorded, then you also need to record the revocation. But as long as the person has capacity, they can revoke that power of attorney. So without powers of attorney, we've discussed guardian would be appointed and or conservator. You can have both, or you can have just one. A circumstance, sometimes maybe someone did their advance directive for health care but never did a financial power of attorney, or vice versa. So just because you get one doesn't mean you have to have the other. Or possibly it's someone who doesn't really have any finances, doesn't have any resources in their name, and so then there's no need for conservatorship, but we do need a guardianship. Okay, so, I think we're going to leave the questions till the end. All right, so don't look at that slide. So now we've talked about incapacity. Now we're going to move into, hey, cheerful topic, planning for death. So the first thing to understand when you embark upon estate planning and you look to get a will in place or to get a trust in place, the first thing, and it sounds basic and it sounds silly, but if you go back and look at your titles, you might be surprised. What do you own? It's very important when clients come in to the office, I send out a set of forms ahead of time for them to complete, and they don't like them because they're long and they're, all this work. They have to get everything together. But it's very important because I need to know what's in whose name. So you can only control the disposition of the assets that you own. So important to say, hey, do I own this jointly with someone else? Is this in my name only? So check the titles. Some items are going to pass by operation of law. What that means is there is a way that they are titled that is going to say what happens to them when I pass away, regardless of what I say in my will. If I say I leave my whole estate to charity, but all my assets are titled jointly with my husband or joint tenants with right of survivorship, he's getting it because that trumps what my last will and testament says. If there's anything on file with that title, for instance, my house, if our house is titled joint tenants with right of survivorship and I leave my estate under my will to charity, the deed controls. just like a joint bank account would control. In Georgia, if there are two names on an account, the presumption is that the survivor gets it when you pass away. With a couple, that generally works fine. That's what you intended. Where it gets a little sticky is where mom had an account and the child who lived in town was on that account for convenience sake because they were local and they were the ones, paying the nurses and the sitters. And then when mom passes away, well, that account belongs to that child because that child was on there as an owner. You can set it up otherwise. Generally, it doesn't happen unless you know to say, okay, I want to be a joint owner on this account, but upon the death of mom, it becomes part of her estate or goes to someone else. So it can be set up that way, but I can tell you, generally speaking, it doesn't happen. And of course, joint tenants with right of survivorship. Maybe you've got a Fidelity account statement or some other bank, and if you look at the title, it says John Doe, JTWROS, Jane Doe. And you think, gosh, I wonder what that means. That means joint tenants with right of survivorship. So it means that when either John or Jane passes away, the survivor gets it. Another thing you might see in that account designation is TOD or POD, transferable upon death or payable upon death. You might not remember doing it, but that means that when you set that account up, you said, when I pass away, I want this to go to my daughter or whomever. It probably won't say it on the account statement, but you could know to go check with the financial institution and say, hey, who does that go to as a POD or TOD designation? Also, the more common thing that you will see is just a beneficiary designation. If you've got a retirement account, life insurance policies, or an annuity, you might have named a beneficiary on that. And so those are going to pass to that beneficiary regardless of what your last will and testament says. One thing to be careful of, if you've had an account forever, and maybe you were married to someone else before, check your beneficiary designations, because I have seen the IRA go to the ex-wife, and it's not pretty when that happens. But the beneficiary designation trumps what the last will and testament says. So particularly if you are in a second time around relationship, make sure that your beneficiary designations are up to date. If you don't name a beneficiary, maybe you've got that IRA or life insurance policy and you never got around to naming the beneficiary. Generally speaking, that will be payable to your estate. Or there might be some financial institutions that put their own hierarchy in there. Say in the absence of a designation, this is payable to the spouse. But usually it's going to become an asset of your estate. With the life insurance, that might not be that big a deal. With retirement accounts, that can be a bigger deal because there can be tax implications there. If it's payable to your estate, the IRA, for instance, would have to pay out faster than it would if it were just rolled over into someone else's name. So in particular on retirement accounts, make sure you've got your beneficiaries lined up because those designations are going to trump whatever your last will and testament says. Okay, so a last will and testament. Your last will and testament directs what happens to your stuff when you pass away. Anything that doesn't pass by operation of law is what's known as your probate estate. So if I've got my retirement account and my life insurance account and a bank account that's titled jointly with my husband, those things are going to pass regardless of what my will says. But if the house is sitting there in my name or I have a money market account that's in my name only, those things will be controlled by my last will and testament, and that's what's known as my probate estate. Very different than my gross estate, which we'll talk about in a few minutes when we start talking about taxes. The last will and testament is where the testator or the testatrix, just male and female of that term, say, here's what I want to happen to my belongings when I pass away. It has no legal effect until I pass away. When I get the call from a child, gosh, mom is just burning through my inheritance. So when did your mom pass away? Oh, well, she's still alive. Oh, well, then that's not inheritance. And so this last will and testament has no legal effect until someone has passed away. That means you can change it whenever you want. If you've got a bunch of last will and testaments, then the last in time is the one that controls. And we've got, sometimes we've got the client who just wants to change their will every 5 minutes. But the most recent one is the one that is going to control, and all those other ones have no effect, and even the most recent one has no effect until someone passes away. So what does a Georgia will have to have? In Georgia, a will must be in writing. It must clearly intend to pass property at death, so it must be clear from looking at it, hey, this is a will. It must be signed by the testator in the presence, so it must be signed by the testator or at his request. What that means is if I have a client, I do a lot of my practice is special needs law in addition to elder law. So if I have a client who's a quadriplegic who can't make a pretty signature, that person, as long as they mentally understand what's going on, can direct someone else to sign on their behalf, or that person can hold a pen in their mouth and just make a mark on the paper. It doesn't have to be a pretty signature. It just has to be signed by the testator who knew what he was doing at the time that he signed the document. It must be witnessed. You've got to have two competent and uninterested witnesses. Competent means over the age of 18, and they know what they're doing. Uninterested, this is an interesting term. Uninterested means that they are not a beneficiary under the last will and testament. So what happens is mom signs a new will, the kids are the witnesses, or two of the kids serve as the witnesses, she has 3 kids. Those 2 kids, because they are witnesses to the will, are disqualified from taking anything under the last will and testament. So I always tell people, just don't serve as a witness to a will, just in case you're in there. Don't serve as a witness to the will. But you want to make sure with your will that you've got disinterested witnesses. Now you notice I didn't say anything about a notary. A will does not have to be notarized in Georgia. As long as you have those 2 witnesses, it is valid. However, it is a better idea to have what's known as a self-proving will affidavit. That is an affidavit at the end of your will that is notarized. The notary says, yep, I saw the testator sign, I saw the 2 witnesses sign, and they all knew what they were doing. By having that affidavit in place, we don't have to locate the witnesses when it's time to probate the will. If we didn't have the notary, we just have a will that has 2 witnesses. When it comes time to probate, we've got to track down those folks. And it just never fails that the will is 30 years old and the witnesses were both female and have been married 3 times since then, and it can be very difficult. I don't know how people did it before the internet. Fortunately, it's a lot easier these days. I'm also married to a private investigator, so that helps as well in tracking these down. But still, just better to have the self-proving will affidavit, though it's not required. So how simple can a will be? Can you write it yourself? Yes, you certainly can. I just told you those requirements of everything. But there are some special considerations that you need to take into account when you're deciding to write one on your own. In particular, some of the things that might cause you to think, okay, I've got a special situation here are if there are minor children or any minor beneficiaries, and even if you've got kids and you plan to leave anything to kids, if one of those kids were to predecease you, ultimately the property could land in the hands of a minor, so that should be taken into consideration. Anyone who has a beneficiary with special needs, I've got one more slide on that in a minute, we'll come back to that. Couples that have taxable estates, you want to make sure that you understand and that you've got your estate plan lined up to minimize those taxes to the best extent that you can. If a major beneficiary is not a U.S. citizen, IRS has special rules. They're afraid that I'm going to leave everything to my husband's not Italian, but if he were, leave to my Italian husband, and then he's going to go die in Italy, and gosh, they're never going to get their hands on that money. So if you've got a major beneficiary who's not a U.S. citizen, there's some special planning that needs to be taken into consideration there. Anyone who expects a fight after they're gone, and you know who you are, if you think that there might be someone who's going to contest your will, then you want to make sure that it was done properly, that you had a proper witnessing ceremony. Also, if there are blended families, not that because just the fact that there's a blended family means there's going to be a fight, but it's just a good idea to get everything lined up and formalized while both parents are still here, and then all the kids know that this really was the plan for mom and dad. So, leaving property to a loved one who has disabilities. One of the things that I had said on that last slide was if there is a beneficiary with special needs, that should be taken into account. Historically, people had thought, well, gosh, I've got to disinherit this beneficiary with special needs because I know they're on Medicaid, I know they're on SSI, and if I leave them anything, it's going to mess up their benefits. And so they thought, well, I've got 3 children, one of whom has special needs. I'm just going to leave everything to my healthy children, and they will take care of their sibling. And even the most well-meaning siblings who absolutely want to do that and would do anything in the world for their sibling with special needs can get caught up in bad situations, whether it's a divorce, a car accident that was their fault, credit card debt, anything. If that money is just left to the other two children, on paper, it's theirs. And on paper, it's subject to their creditors. So you can set up a special needs trust. It is a trust that is invisible for purposes of Medicaid and SSI eligibility. It does not affect an individual's benefits. Put the money into the special needs trust. Those two kids that you want to oversee things can still be in charge. They're still the trustee. But it's just that that money is not theirs and it's not subject to their creditors, but they can still oversee it for their sibling. So property in that trust does not count for purposes of Medicaid and SSI, nor is it subject to Medicaid payback. And if you're involved in the special needs world at all, you know what that means. But reimbursing Medicaid for any care, if property is left under a will to a special needs trust, there is no reimbursement required. So once you have a will, this is another common question. Okay, when do I need to update it? Is there a rule of thumb? I'd say as a rule of thumb, every 5 years I would take it out, look at it, make sure that you still like all the people that are in there, you're still married, or if anyone's name has changed, those types of things, get those updated, or any major life change, a new child, change in marital status, health status, retirement, a move, anything like that. Any of these triggering events would be a good idea to take a look at your last will and testament. Marriage, divorce, and having another child do not necessarily invalidate your will, but it probably changes what you want to do, or maybe you just want to make it clear that it doesn't change what you want to do. So certainly those events are important to review your will. When you're setting up a will, you're going to be naming fiduciaries. These are the people that you're putting in charge. A guardian for minor children, or if you're serving as a court-appointed guardian for someone, that would be addressed in your last will and testament. The designation of a guardian is strongly considered. It's not binding on the court, so if I name my sister and in the meantime she develops a drug habit, the court doesn't have to place my child with her. They can step in and find a more suitable guardian. An executor, this is the person who gathers up your assets, figures out what you own, pays off what you owe, and then distributes assets in accordance with what the last will and testament says. In Georgia, an executor only has to be on the hook for 6 months. Not necessarily common that everything is done within 6 months, especially these days when we're waiting for houses to sell and things like that. But the executor duties are much shorter potentially than trustee duties. If you're naming a trustee, this is the person who's going to oversee the assets for the lifetime of that beneficiary with special needs. Could be 30, 40 years. Or a minor child. If that child's only 6 months right now and you're going to keep it in trust till they're 30, you need to take that into consideration when you're naming your trustees and get successors lined up. Not necessarily having someone in place now, but just making sure that you've got good successors lined up in case something happens given the young age of that beneficiary. How do you revoke a will? The best way to do it is to sign a new one. If you have a will, go and look at it, and it's probably going to say, I hereby sign this last will and testament, revoking any other last will and testament previously made by me. That's going to be the best way to do it. You can destroy a last will and testament, just rip it, shred it, do whatever. If you're going to go that route, you should probably be putting a new last will and testament anyway in place, so then we're back to the bullet point number 1, just sign a new one to revoke the old one. But if for whatever reason you're destroying the will and intend for it not to be probated, you need to make sure that you destroy the original as well as all copies. Let the attorney know that if someone did a will before and you went to a new attorney now, send a letter, say I've revoked that last will and testament. We don't take it personally. But it just lets me know that if your daughter calls up and says, oh, mom died and we can't find the will, well, I've got one here from 1980, but I don't know if she did a new one since then. So just a good idea to keep those things updated. How do you amend a will? Maybe you just want to make a little change to your last will and testament. Maybe you just want to change your executor. You can do what's known as a codicil, fancy word for an amendment. Be very careful in doing these. You need to be careful in referencing back and forth between the codicil and the will, what is changed, what isn't changed. Certainly don't attempt these without an attorney. They need to be witnessed, notarized, however the first will was executed. The codicil needs to be executed in the same way. And my concern with codicils is you put your will in this drawer and the codicil's over here in this drawer because you did it a few years later, and then this will gets probated and then whoops, we find the codicil. So good idea to at least keep them together, staple them together. In this day and age of word processing, I've probably got the old will on the computer, so let's just make the change and do a new one, and I feel much better about just having a full new last will and testament in place as opposed to doing a codicil. If you die without a will, what happens to your stuff? Everyone tends to think the state gets it. No, the state doesn't get it, but the state decides who gets it. Georgia basically writes a will for you, and it says who gets your property. A spouse is entitled to at least 1/3, but upon the death of an individual, property gets divided between the spouse and children, regardless of those children's ages. So, for instance, if you've got a spouse and 40-year-old twins and you pass away, your estate is getting divided a third, a third, a third. The surviving spouses don't tend to like that very much. And it becomes a hassle. So it's a surprise. A lot of people think, well, I don't need anything. Everything's going to go to my spouse anyway, but that's not what happens under Georgia law. So important to put it in writing what it is that you want to happen. If you don't have a last will and testament, your property might not be distributed as you want it to. Also, it can be a more difficult process. If you have a well-drafted last will and testament, it can relieve your executor of filing bonds, or posting bond, filing returns with the court. You can do that under an administration without a will, but it's just more difficult. So getting a will in place on the front end saves a lot of aggravations on the back end. It also allows you to choose who it is that's going to be your executor, which wouldn't be the case if you didn't have a will. Okay, so a trust. A lot of people say, well, what's the difference between a will and a trust? And first, before we get into comparing and contrasting those two, I just want to explain what a trust is, because a lot of people tend to think, well, yeah, I know what a trust is, but it's kind of an abstract thing. A trust is where you want to separate the benefit of the money from the control of the money. So I tell people to think of it like a triangle. We've got our triangle, we've got the person with the money, the person who's going to benefit from the money, and the person who's going to control the money. So there's our triangle, and the money's just there in the middle. So the donor gives the property to the trustee, who holds it for the benefit of the beneficiary. To put a little, more finite terms to this, if I leave $10,000 to my brother as trustee to hold for my daughter, and then I say he can use the money for her support and education, and when she reaches 30, she can have whatever is left outright. So there's my trust. This is a broad trust. He can use it for her support and education up until she turns 30, at which point she can have it. So it's important to realize a lot of times like this with a trust for kids, you're just picking the age at which you're comfortable with them getting their hot little hands on that money outright. In the meantime, it can absolutely be used for their benefit. They just have to go through the big bad trustee to get it, and they might only be getting that Honda Accord instead of that Lamborghini that they had their eye on. But that's probably exactly what you intended. So when you want to separate the control, then you've got the triangle and you've separated it. Now, maybe you don't want to separate that control. This is where we contrast a will versus a living trust. Suzanne was asking about the living trust. With the living trust, you could set up a trust where you are all three parts of the triangle. You are the person with the money, the person that's the trustee, and the person who's benefiting from it. Under that model, you then retitle all of your assets in the name of that trust. And you say, when I pass away, do the following with my trust. So I set up my trust, I title my house, my bank account, everything in it. I'm the trustee. It says as long as I'm alive, I'm the beneficiary and I'm controlling it. But what happens is then when I pass away, I don't own anything. My trust owns it all. So there's no need to probate my will. There's no need to go to probate court. Instead, the trust just says when I die, give everything to my kids. And so that gets handled that way. So that's the big difference between a will and a trust. Also, some people like these trusts. In the meantime, a lot of attorneys will say that financial powers of attorney are too difficult. The banks give you too hard a time. And if you put everything into a living trust, then they don't give you as hard a time about using a power of attorney. So that can be another benefit. It avoids probate and it also provides privacy. All right, our last quick topic here is going to be transfer tax. And it's gotten a lot quicker recently to cover this topic because the numbers have gone way up and the rules have actually gotten a little bit simpler. So the IRS takes an interest whenever wealth transfers, whether it's a transfer because someone passed away, something was given away. The IRS wants to know about it. So that can be a transfer by virtue of inheritance, or someone with the inheritance and estate go together, or someone just gives it away. And then there's also the generation skipping tax, which I'm going to cross off the list here really quick because it is complicated. And all you need to know about the generation skipping tax is if you have a taxable estate and you want to leave property to grandchildren, great nieces and nephews, you're skipping a generation. There's a higher tax ramification to that because the IRS says, well, if I give everything to my grandkids, it's going to be a long time before they pass away. So they might spend it all, and then there'd be no estate tax owed on that. So if you're skipping a generation like that, you want to consult your attorney and make sure you've got the appropriate planning in place. For the inheritance tax, in Georgia, there is no inheritance tax. What that means is there's no federal inheritance tax and there's no state inheritance tax in Georgia. That doesn't mean that estate tax was not paid up here. If I pass away, I can have $5 million without having to pay estate tax. If I pass away, my $5 million can pass to whomever I want without having to pay any tax on it. But that $1 million would be subject to estate tax. So that estate tax gets paid, and then the remainder, $600,000 potentially, the highest estate tax bracket is 40%. So $600,000 would then go to my beneficiaries. My beneficiaries don't have to pay an inheritance tax on that because my estate has already paid an estate tax. So that's the difference between those two. For tax purposes, your estate includes, I'm rushing through here at the end to finish up. For inheritance purposes, estate tax purposes, your estate includes everything that you owned. You might not feel like a millionaire right now, but if you have a $1 million life insurance policy, that counts as part of your estate. And that would be taken into consideration as part of your estate unless you set up an insurance trust to get it out of your estate. So here are the numbers I was just telling you about. $5 million per person, so $10 million per couple. So a lot of people tend to tune me out after I say that, like it doesn't apply to them. Those numbers have increased gradually and then pretty dramatically here the past couple years. You can give $14,000 a year to a person without telling the IRS about it. If you give someone $15,000, then you need to file a gift tax return saying that you gave $1,000. You can give $14,000 to every kid, every spouse, every grandchild, every year without telling the IRS about it. You can do it in December, turn around and do it again in January. So important to realize that, but if you're going over that amount, then you need to file an estate tax return and tell the IRS about it. You're allowed to give away $5 million during your lifetime before you have to pay any gift tax, but you still need to disclose it and let the IRS have it on record.
Just one point, I don't want to mention, a couple could give 14 each.
Yes, each spouse, so $28,000 between the two of you, $28,000 to every kid, grandkid, lawyer, whoever. Okay, so, most people avoid the estate tax by just not accumulating that much money, especially these days, but there are things that you can do if you want to take that into consideration in your planning. So that finishes it up for me, and now I'm very interested to hear what Dr. Hug has to say about the Advanced Directive for Healthcare.
Thank you very much, Heather.
I'm going to refer to some websites that you can cite, and I have copies here of the websites. I think Isha said that she can also email those to you. So my background is as an anesthesiologist, intensive care doctor for about more years than I'm on. And now I'm linked to the Ethics Center, and the advanced directives have been part of my practice all the way along. So everyone wants to live long, but no one wants to die, to be old. Everyone wants to go to heaven, but no one wants to die. But the best one is, I don't fear death, I just don't want to be around when it happens. So the priorities for most individuals at the end of life, living and dying at home. Spending time with family and friends, being comfortable, having pain relieved, avoiding burdensome interventions, not being subjected to forced intake of food and drink. That comes up time and again in surveys or just talking to patients. They want to die in hospitals. But 70% don't want to die in hospitals, but 70% do die in hospitals, often in ICUs. So a good death includes pain management, aggressive comfort care, maintenance of dignity, a feeling of connectedness, freedom of being burdensome, and financial control. So six things you can do for your family before you can't do them. Living will and durable power of attorney for healthcare decisions. Durable power of attorney for healthcare decisions, and as you've already said, that's different from a financial durable power of attorney. The more important thing is having discussions with your family members about your wishes. Even some people are now making audio videotapes where they discuss what they enjoy about life and how they feel toward their family. And as was mentioned about your financial assets, having a advanced directive relieves the family of burden. So, and then of course, the last will and testament's already covered. Location of important documents. It may not be for everyone, but I gave my wife a gift years ago. I gave her a list. It's now grown to about 12 pages, but it's got everything on there. Who she has to contact, the CPA, the lawyer, the minister, where every asset we have, IRAs, house, who owns it, all the things that you mentioned are in that document. But make sure your kids, and certainly anybody that is your surrogate, knows where those are. And I'm going to talk about it in a minute, but do not put a durable power of attorney for a healthcare decision in your safe deposit box. In fact, Sandy Atwood, who's the former president of Emory, built a new house in North Georgia, and a friend of his went up to visit him, and when he went in the foyer, he noticed two doors, symmetrical foyer, each had a plastic bag on the door handle. So he went in, they had a nice visit, but as things wind down, you carry on conversation in the foyer, and he said to say, what are those two plastic bags? Those are advanced directives. We're going to grab them as they take us out of here. And I think it's a good idea to describe your funeral arrangements and plans. I've been through this with both my parents and my mother-in-law, and you go to a funeral home, they're going to sell you like an auto salesman sells you. Oh, a pine box would not honor your mother. Well, it'll do the same thing as a nice fancy $24,000 one. And clean out the basement, attic, and cupboards. I feel like Kubler-Ross, who said the stages of grieving. That's one I haven't done yet. I got to get on it. All right, let's talk about advanced directives. First of all, there's a living will. And traditionally, that is a checkoff box. I do or do not want a feeding tube, connection to a ventilator, whatever. It's a very blunt instrument because it doesn't take into account circumstances. And so, I've had patients who had an advanced directive that said no feeding tube, but they needed a feeding tube only for a short period of time to restore their strength so we could get them separated from the ventilator. I've had several of these frail little old ladies, and everything was perfect. And we take the ventilator away, and about 45 minutes or an hour and a half later, failed, and have to attach her back to the ventilator. She just didn't have the strength. So you have to have some ability to have flexibility, and that's where a surrogate with a durable power of attorney for healthcare decision comes in. And I've already mentioned conversation with family members. You mentioned the Georgia sequence for there's a hierarchy. Well, the same is true when you have the inability to speak for yourself. Generally speaking, your living will has priority over anything else. And so, depending on how people interpret that, physicians interpret it, and they don't all interpret the same, you may not get what you want. You may get more than you want, in fact. So, again, have the conversations. In Georgia, the spouse is the first below your living will. And then after that, there's a whole sequence. And recently, it's been modified to include a significant other who is not your spouse, gay couples and so forth. I didn't bring that slide with me, but you can look it up on the Georgia Code, and I'll show you that website in a minute. As I mentioned, videotape declarations are something that's come into fashion a little bit, but I think they're a good idea. And do not resuscitate is a form of an advance directive, but it only restricts, if you have a do not resuscitate, DNR, only restricts the use of chest compressions and electrical power from Georgia Power, cardioverting, defibrillation, and so forth. Any other therapy can go on. It can even be increased. So this is a misunderstanding that many folks have when approached about a DNR order for their loved one. They often think, well, you're just going to abandon grandma to the corner room and ignore her until she dies. No, that's not true. DNR, I have another definition of it. Do not relax. Okay? And when we talk about advance directives, they can be changed at any time. They can be revoked. They can be revised. As your condition changes, you may want to change it. Okay? My living will. Last night, my friend and I were sitting in the living room, and I said to her, I never want to live in a vegetative state dependent on some machine and fluids from a bottle. If that happens to me, just pull the plug. She got up and plugged my computer and threw out my wine. Things your surrogate and family members should know. Your views of life and death. You know, what do you enjoy? And one of the things that I try to talk about every time I address medical students or residents, we in healthcare see terribly traumatized patients or terribly sick patients ravaged by disease. We say, oh my God, I never want to be in that situation. Well, yeah, but when you get into that situation sometimes, you find out you can have a life. And we have a classic in our department. Pat Kelly was going home, young guy, going home from a shift at Grady at night. And he rode his motorcycle up Peachtree instead of Piedmont. And why he did that, I always went up Piedmont, but he went up Peachtree. He stopped at a red light, T-bone crash, two cars, one goes through a red light, and one of the cars runs over him. And he ends up in Grady. And they come in and tell him and say, well, Pat, we got bad news. You'll never walk again. You're paraplegic. Then a few days later, they come in and say, you won't have children. Real downer. And then a few days or weeks later, they come in and say, you won't have control of your bladder and bowels. Oh, my goodness. He said, I'd rather be dead. But they transferred him to Shepherd Spinal Center, and you have a ring of people sitting around when you come in there, and they basically say, Pat, look at all of us. We're all disabled. We've got a life. You can have a life. It became an inspiration to all of us, still is. He tools around Emory in his wheelchair on the pain service, always has a smile on his face, carried the torch for the 1996 Olympics, was an advisor to the Olympic Committee on Disability Access. He travels to Europe. He has to make special accommodations. It takes some extra work, but he's happy to be alive and be able to do it. The person designated as your surrogate, not always your family members, especially if you got conflict there. So be sure it's somebody who can be true to your wishes. And having a surrogate who speaks for you when you can't speak for yourself relieves the family of a burden. Sometimes, as a physician, I would approach a family and basically say, would you want us, the healthcare team, to make a decision? And they would say, yes. My mother-in-law was dying. She was up in Massillon, Ohio. I called up there, the physician taking care of her said, multiple organ system failure and so forth, but one granddaughter said, no, we're not withdrawing support. We didn't. Because to have that person perhaps in some later time say, you killed my grandmother, is something more than you want to have happen. So unfortunately, her grandmother lived for 2 and almost 3 years, totally demented. Her husband's a saint. You had to watch her every minute. She'd put a pan on the stove, they had a gas-fired stove, and walk away and leave it. She went out on the street inappropriately clad. So he had to take care of her colostomy, bathe her, and do everything else. So it's important that there's a consensus when these things come to the end. And be sure your physician knows what your wishes are. If you have your primary care physician. I'm from La Crosse, Wisconsin. The whole town is committed to advanced directives. They started at a very early age, 30s, 40s, start talking about, end of life thing. Because you don't know what's going to happen to you when you leave this auditorium. We've had 2 people killed out here in Clifton Avenue. It's been some time ago. They put that bridge up to avoid that risk. You know what's going to happen to you. There's a friend of our family who fell down some steps at Savannah, and he's incompetent. He's probably going to be declared in a persistent vegetative state. All he did was fell down the steps, hit his head. So here's some sources of information about forming living wills. A good one that's for free, you can download it. I have the sites here on these pieces of paper, which you can pick up. I'll put them out on the desk. It talks about your overall attitudes toward life and health, your personal relationships, thoughts about independence and self-sufficiency. One of the greatest fears of most people is loss of control. And when you're dependent on somebody else, you resent it. You resent yourself being dependent on that individual, putting them to extra work. Talks about your living environment, religious background and beliefs, relationship with your physicians, thoughts about illness, dying, and death, and issues of finances, legal documents, and funeral plans. You can simply Google it, values history form, and you'll get it. You can download it. And it poses questions, the form poses questions to you that you write out the answers. This is one that we're using at Emory, the Critical Conditions Planning Guide. You can Google the Critical Conditions Planning Guide and download it for $7.50. It's a well-written document. It starts out by telling you little vignettes of patients and asks you, well, how would you respond? What would you want in this situation? And it goes through a series of these, and then it gets to the issues for you as an individual. It poses questions that, again, you write out what your thoughts about the questions are. And then the Georgia Advanced Directive for Healthcare, again, you can download that. There's a website, agingdhs.georgia.gov. And there's about 15 pages in the form, but there's 14 pages of explanation beforehand. And it, again, goes through questions and so forth. In fact, we're combining it with the last one that I showed you. Combining it, whoops. What the dickens? Sorry. Let me get this. So we're combining this and the Georgia Power Advanced Directive for Healthcare. The first part, you designate your healthcare agent and successor agents if you have a sequence of people you want. It talks about your treatment preferences, guardianship, and then the part 4 is the signature. It does not have to be notarized. It does have to be witnessed by one person. It's very easy to fill out. Takes a little time, but it's worth it. And then here's a CDC site where they have 19 websites on advanced directives guidance, 2 websites on hospice and palliative care, 4 websites on caregivers and healthcare surrogates, 2 on cognitive impairment, and 5 on legal issues. So there's a wealth of information on the internet. And that's it. So, do you have questions or comments?
Yes, thank you very much, Dr. Hope.
The preceding program is copyrighted by Emory University.